Fantastic. So just for a visual cue, I have kept some content on the screen today so that it helps you to focus.
इस लैपटॉप से हुआ था कॉलेज
Okay. To anchor something on your eyes as well, I will heavily motivate you to ensure that you are using a pen and paper to write down questions today. Okay, if you have any. Now, this is a huge chapter again. These two chapters includes around 50 pages of approximately discussion what we'll have today. So the chapter 4 is basically the summary of this particular chapter is the purpose is it outlines the power of the investigation of the police. One minute, let me switch off my sound. So, what is the investigation power given to the police, under officers, and public in general, emphasizing their role in maintaining law and order? So, arrest is something which is a physically, putting somebody in a place and dividing him of any further locomotive movement to move from one place to another place. And that can be facilitated lawfully for lawful reason by the investigating team, by the police officers, by the magistrates, by the commoners, or on instance of such magistrates. And the sole purpose only and only can be to maintain the law and order. So the only purpose could be maintaining law and order. Now, it specifies chapter 4, the procedure and how to conduct these particular activities. Now, why this has chapter 4 is there is because to ensure effective crime investigation, because to investigate, you need to get hold of that person. Further in chapter 5, you will see you get hold of the person, then you need to have the right person whom you have get hold of, how to identify that person. Also, in chapter 4 and 5, especially in 5, you will see how the protection of the rights are also taken care by such procedures. So, CRPC is not only, as we discussed yesterday, it is not only something which is required to facilitate the legal action against the accused only, for the victim only, and against the accused only, because it is also something which is very, very important to safeguard the right of both accused and victim. And with all this, we have an efficiency in place, as we discussed yesterday, because there is a structure in place, right? So, overall, the framework is this is what is in chapter 4. Now, power of superior officers of police, which is chapter A, chapter 4, subchapter A, section 36. So, if you see on the screen, police officers superior in rank to an officer in charge of a police station may exercise the same powers throughout the local area to which they are appointed, as may be exercised by such officer within the limits of this station. Now, if you see, there are certain things which has to be very, very much careful about. So, officer of superior rank. Okay, this is one thing which is key. Same powers. Okay, throughout the local area. This is again very, very important. So, these ingredients should match. What should match is the person should be superior to the certain police officer who is officer in charge of the police station. So basically, if we see Pune, so any station in charge is a 3-star, is a senior PI, as we call senior police inspector. The just above to him is in the urban areas is the ACP, in the rural area is the DSP, and above then the hierarchies go on. So an ACP, if we see in Pune's context, is an officer superior in rank, and anybody above ACP is superior in rank. So up to the police chief of the particular district or the state, this hierarchy goes. So normally the person should be a senior superior officer. So anybody who is above the rank of that particular officer and are in the rank of investigation. So up to the rank of CP, mostly investigation is primary or secondary duty. And mostly up to DCP, it's a primary role of administration plus um, uh, investigation plus administration. Now, The very, very important thing to be kept in mind in this section is throughout the local area. Now, there is a very famous case called State of Kerala versus PB Sorban. So, State of Kerala versus PB Sorban is the case where Supreme Court has come back, and the facts of the case were one officer was accused of not conducting the investigation properly. So, in this situation, when the complaint was made to the police chief of the police chief of the district appointed one assistant commissioner of police to do further investigation. He came back with some deficiencies in the investigation, but then he could not really support the victims in helping doing the right investigation against the accused. Now, in that scenario, the public prosecutor, the the APP, all those people came back on behalf of the state and the victim, coming back and saying the ACP who was appointed is not somebody who could be eligible to be doing this investigation because he's part of some other zone in the district. So he's like in Pimpri or in Pune, you have zones divided: zone 1, zone 2, zone 3, zone 4. Every zone is headed by one DCP, and every DCP has then multiple ACPs under them, and every ACP has multiple police station. They're in charge below that. So very similarly, this ACP was not from the same zone, and that was the challenge which was put in the court. So in this famous case of State of Kerala versus PB Sorbam, uh, and also there was one more matter of Union of India versus Ashok Kumar Sharma and others. This is a Maharashtra matter. So, in these both matters, Supreme Court has come back and clearly say superior police officer should be allowed to investigation if required in place of the officer in charge or anybody below him as per section 36 of CrPC, but he and she should be only from the local area. So in that case, the application was accepted in this case by the honorable court, and that particular investigation was considered null and void, and fresh investigation with a senior police officer was required. Uh, this is about section 36. So this completes the power of the superior officer clause in section 36, the section in chapter 4. Coming to part B, aid to the magistrates and the police. Now, as the name says itself, chapter 4, section 36, after section 36, the sections are included in part B, which is aid to the magistrates and the police. So, what aid means? To support, to provide some relief. So, what kind of support could be provided by the people who could provide, for example, public, to the magistrate and the police in execution of the justice system in criminal law? So, the first section says public when to assist magistrates and police. So section 37 is about when a person from public or group of people from public can assist a magistrate and a police. Now, every person is bound to assist a magistrate or police officer reasonably demanding his aid in the taking or preventing the escape of any person whom such magistrate or police officer is authorized to arrest, or in the prevention or suppression of breach of peace, or in the prevention of an injury attempted to be committed to any railway, canal, telegraph, or public property, or any such public property. Now, in total, it mandates that every person is bound to assist a magistrate or a police officer when reasonably demanded. So it has to be a reasonable demand. A police officer cannot come back and force you to do something which is in not your hands. I think we lost Durga. I think she dropped. Let's wait for her to join for a minute. I'll pause the recording for a while. I'll wait for 1 minute for her to join. Otherwise, they'll have to continue. Can one of you check with us? Or in interest of time, I have to start in 1 minute. Okay. We'll wait for 30 more seconds. We'll start. Okay, we'll resume. Now, so this whole uh, CRPC is all about having the as much best possible um, legal justice system for the criminal offenses. Now, in that particular, the role of the public, wherever they can come and help and be part of the criminal justice system, is also to be highlighted. Now, in that very same, on the very same particular perspective, this aid to the magistrate and the police comes. So, Section 37 roughly says it is mandated that everybody is bound to assist a magistrate or police for a reasonable demand. They cannot come back and ask you to kill somebody, to shoot somebody, or to jump a wall, or climb a wall. So whatever reasonable you could do, which you cannot deny. So it has got an other side also. In court of law, you just cannot come back and say that reasonably I was not able to help because I was not able to grab that person. You might be afraid of the shape and size of the person. That is something which is acceptable. But for all such reasons, if you do not do, you might need to come back and explain to the court also why the burden of proof is on you, that you have to come back and say that why you were not able to help. So other side also it works in the other direction. So it is for the sake of preventing the escape of someone who could be lawfully arrested and preventing or suppressing a breach of peace or preventing injury to public property. So in all the three cases, if somebody is escaping, it's quite possible that a police officer is there and he or she might not be physically as much capable to single-handedly arrest somebody, and the person is escaping from his or her hand, and in that case a magistrate or police officer whom they are supposed to authorize to arrest can come back and say please help, and if you are capable enough you should help without, if you see any there is no fear of injury or any kind of adversities to yourself. In prevention or suppression of a breach of the peace, if somebody is doing something which is preventing a breach or a peace, for example, some people are coming and making noise unnecessary and they are shouting, and you are there as a common public standing in a good number, so then all of you could come back on request of the police and help. If you are not helping, that is something which you are going against Section 37B of CRPC. And in the prevention of injury or attempt to the committed to any property, not only railway, canal, telegraph. This is an old written word. That's the reason they used canal, telegraph, railway. But then it could be anything. It could be Pune Metro as well. So the circumstances which will require assistance would be taking or preventing of escape, preventing a breach of peace, or preventing injury to public property. So in all these three conditions, you should be able to aid the magistrate or the police in case they ask you for a reasonable help or support. The famous case law of Raghubir Singh versus State of Uttar Pradesh, this talks about the same. In which this where a police officer faced a resistance while attempting to perform a duty to arrest somebody. The public, instead of helping to maintain order, they did not supported the police officer. The person was trying to escape, they could not help. So in that case, this was ruled against those people. The court has ruled again, and the Supreme Court held that the citizens who were present there have an inherent responsibility to assist the police in maintaining peace and order. So the court underscored that cooperation from the public is essential for law enforcement to perform effectively, and thus the High Court's order setting the people who were available there, acquitted, was overturned, and then they were fined by the Supreme Court later. So what is important is this: look it from the perspective of whatever I teach you. Look it from the perspective of your client and advocate relationship as well. You might be standing for such a crowd or against such a crowd at some point of time in your career, and then this every section which I'm teaching, you should always think, if I'm an advocate in such situation, what I would have done. And in that sake, if a question comes to your mind, write it down so that we can discuss at the end. That's how the maximum benefit of the program will come. Similar situations was in Bhim Singh versus State of Jammu and Kashmir, which is a 1985 matter. Same was State of Tamil Nadu versus KS Damodaran. It's a 1981 matter. And Kahar Singh versus State, 1989. So these are some very famous cases which talks about Section 37, where the courts of laws, whether it's Supreme Court or whether some High Court, they have come back and they have said why it is very much necessary for you to come and help a police or a magistrate in the need where it is required to sustain the law and order for them with your help. And it has to be reasonable. So this is section 36 about the power of the senior police officer, their limitations, section 37. Now let's move to section 38. So section 38 reads, when a warrant is directed to a person other than a police officer. So warrant is issued, normally we know warrant is issued, a police officer or a law enforcement officer from any other such department will come and execute that warrant against that person or persons. So once this warrant is issued and it is directed to a person other than a police officer, any person may aid in the execution of such warrant, if the person to whom the warrant is directed be near at hand and acting in the execution of the warrant. So this is again part of the same aid where common public commoners can come and help. And this is section 38 basically deals with situation where warrant has to be issued and someone who is not a police officer has to execute the warrant. So when we use a warrant and we arrest somebody, it's called execution of the warrant. So the person has to be execute the warrant. Now the purpose of the section is it aims to ensure that the warrants can be effectively executed, even when the person to whom the warrant is directed is not a police officer. There might be a situation where a warrant is executed to produce somebody to the magistrate or summon him to the nearby police station or something like that. It is far most important what CRPC says in through this clause is this is far most important that the execution of the steps of the judicial system, the legal judicial system, the legal machinery should be executed and it cannot be blocked just because for some reason, for some valid reason, a police officer is not around. So if a warrant is directed to a non-police officer, that person can also assist in executing that warrant. However, it is only permissible if the person to whom the warrant is directed is present and actively executing the warrant. So the warrant also cannot be issued to just somebody who is supposed to be there. The warrant is always executed to such people who are 100% supposed to be there and fully locomotory active and supposed to be in a good shape to execute that. So the honorable courts definitely would believe and have strong reasons when they will issue that warrant. That is also one of the perspective of section 38. And the persons assisting in the execution of the warrant will have the same authority, protection and status as if they are a police officer. For the time being, when you accept the paper of warrant and you move and you execute the warrant and you bring that person to the nearby police station or wherever designated place the court has asked you to bring that person, for that span of time, you have exact status of a police officer. You are protected as a police officer. So if anybody comes and tries to force you from not doing it, and if you ask for aid of somebody to help you in doing the executing that warrant, all those things which are applicable against commoners by not aiding the police or the magistrate will be applicable to those people as well. So you become a temporary police officer during that direction. For example, very famous case law is Nirmal Singh versus State of Punjab, where a legal question was revolved around the same thing, where citizens in executing warrant are they can they be involved with that or not, and on which the court upheld the validity of action taken under section 38, confirming that when a warrant is executed, citizens may legitimately offer their assistance, particularly when the warrant holder is present and actively engaged. So it could be other way around also, that the warrant is issued to somebody known as a friend of the court or friend of the law, and the person is might be allowed, and the person becomes a police officer, then all the applicability of the law to support and to receive the aid by a police officer is applicable to you as well. Or you might offer yourself also if asked in the court of law, and then your assistance is most welcome, and you could definitely provide that assistance. Coming to the next section, which is a little big in size, don't get overwhelmed. It's not to worry much because the sections which are mentioned here, we need not go through all of them right now. We'll go through them once the time comes when we reach those sections. Right now, they're only meant to give you an indicative presence. So section 39 says public to give information of certain offenses. Now, aid in the first case was an active aid, where somebody, police officer or magistrate, is asking you for an aid and you go and help them, or you execute in place of a police officer. Now, this section 39 talks about public to give information of certain offenses. So it is a crime if you are supposed to know some information. It is very clear by the law, in eyes of law, that you were aware of everything, and then you were not aware of, you are not disclosing it to the relevant police officer or the magistrate. So every person aware of commission of or of the intention of. Now you see here, even if you are aware of a plan of certain crime, cognizable offense which is going to happen, or the groups of crime which is listed further below down, I'll go one by one to them. So in all those cases, the person, even if they are aware of the intention of any other person to commit any offense punishable under any of the following section, should inform the relevant police station. So tomorrow, if it is somehow proved that you were aware that there was a Dakati plan which was going to happen, you very well were aware of that. It was very well done in your presence, and you could have come and informed police. You also become a party in one of the offenses under section 39. You will be also prosecuted. So, what are the such cases which under which you should be careful, and if you are aware, or your client should be aware, if the offenses are happening, they are supposed to come and help the law and order by informing. Section 121 to 126, both inclusive, and section 130, that is to say, offense against the state specified in chapter 6 of the said code. Then offenses against the public tranquility. So whatever sections written here are from IPC. Then number 3 says offenses related to illegal gratification, so bribery, etc. Offenses related to adulteration of food and drug, etc. Offenses affecting life, kidnapping and ransom, offenses of theft and preparation made for causing death, hurt or restrain in order to committing the theft, offense of robbery and dacoity, offense relating to criminal breach of trust by public servant, offense of mischief against property, offenses of house trespassing, offenses of lurking house trespass, and offenses relating to currency notes and bank notes. All of these offenses are considered offenses where if you had an information, you were supposed to report definitely. And reporting crimes helps the law enforcement agencies and the public work together to create a safer society, because end of the day, it's a responsibility of the common people also to ensure there is a safety and law and order maintained in the society for their living. So the law and order system machinery is established for that. The police and the other departments are there. But what section 39 says, if you are aware of such offenses, you are supposed to definitely come back and report all these things. For the purpose of this section, the term offense includes any act committed at any place out of India which would constitute an offense if committed in India. So, even if something which is committed near to India or outside India, those offenses are also included in this. Coming to section 40. Now, duty of officers employed in connection with the affairs of village to make certain report. Now, why this section is there under the aid to magistrate and police? Because these officers which are appointed in this particular class of people, which we'll know shortly, and the kind of crimes which are mentioned here, these people are not police, these people are not magistrates, but they are still the village officers, and affairs, they take care of the affairs of the village. So apart from the common people which are listed in section 39, where they have to come back and disclose to the law and order system machinery that this is what is happening, and they are supposed to report that, these officers are also not spared, because they have an extra responsibility of also taking care of the affairs of the village, and so they have an additional responsibility to come back and inform. So every officer employed in connection with the affairs of village and every person residing in a village, so both, shall forthwith communicate to the nearest magistrate or to the officer in charge of the nearest police station, whichever is nearer, any information which he may possess respecting. Now, before I go any further, section 39, whatever clauses were there, whatever crimes were mentioned there under IPC, which needs to be informed to the police or the magistrate, is automatically covered under section 40 also. So it is inclusive of those crimes plus the permanent or temporary residence of any notorious receiver or vendor of stolen property in or near such village. If that person is seen, you go back and report the police or the magistrate, mostly police. The resort to any place within or the passage through such village, any person whom he knows or reasonably suspect to be a thug robber, escaped convict, or proclaimed offender is seen. The commission of or intention to commit near such village any non-bailable offence or any offence punishable under 143, 144, 145, 147 and other such sections. The occurrence in or near such village of any sudden or unnatural death which is happening, or any death under suspicious circumstances, or the discovery in or near such village. So, any such suspicious death, or a corpse found, or a part of a body is found, the person or the from the village panchayat or the officers of the village plus the villagers are supposed to inform in circumstances which lead to reasonable suspicion that such a death has occurred to or the disappearance from such village of any person has happened. So this has to be reported. The commission of intention or intention to commit of any place out of India near such village, any act which is committed to in India would be an offence under so and so section is also to be reported. Any matter likely to affect the maintenance of order of the prevention of crime or safety of persons, so anything on the earth. So section 39, everything or property respecting which the district magistrate by general or special order made with the previous sanction of the state government has directed him to communicate information. In this section, village includes village lands and expression proclaimed offender is defined in further CrPC. You will come to know today. So the duty of officers employed in the connection with the affairs of the village to report such matters, including sudden or unnatural deaths, suspicious circumstances, and disappearances, as well as matters affecting order or crime prevention. Okay, so all those things have to be taken care. Now, with this, we move to uh, chapter 5. But before that, let's summarize what we have seen in chapter 4. So, the chapter objective is to outline the powers of the people like police, other officers, public in general, emphasizing their role in maintaining law and order. It talks about the power of the senior officers of the police, investigation related things like conducting arrest by the common people, citizens' duty, circumstances for assistance, public cooperation, citizens' duty to assist law enforcement, police duty to prevent breach of peace, collective responsible of public and others for part of the law and order machinery, public assistance in law enforcement, warrant execution assistance, citizen assistance in arrest, reporting obligation by common people and by the villagers and the village officers, exceptions to reporting. For example, reasonable excuse is required to avoid reporting, and the burden of proof for this excuse lies with the individual. So, in case if you believe there is something which is you don't want to report, then please be ready if tomorrow, if that is something which becomes a cognizable offense and where somebody is, apprehended by the law and order, and it was discussed and it was found that you were very well aware of that. So, in that case, it is your responsibility, which will be accounted for, to not you that you have not revealed that to the law and order, and it's your burden of proof lies to you then that why it was not reported. And applicable offenses are all given, which are mostly public offenses and even individual offenses in some cases. So this is what it concludes the chapter number 4. Chapter number 5 is a huge chapter, which is the arrest of persons. Before I get into the chapter, I would request you once again to very closely listen and note down the important key points for discussion or for asking questions. This is a very wide chapter and it has got very wide dynamics. There had been a lot of changes over time recently in this particular chapter in CrPC. Of course, in BNSS, it is very much changed now. So, but chapter 5 becomes a base for you right now to understand the arrest of persons. Now, arrest of person chapter, when it talks about it, it doesn't only talks about the arrest. It talks about all the dynamics of arrest. When you arrest somebody, how do you arrest somebody? In what circumstances? What procedure? in which cases you can arrest with warrant, in which cases you cannot arrest with a warrant, without a warrant, in what could be the specialized cases of arrest, what are the specialized procedure for arrest, what is the search mechanism, how do you produce the person to the court, why when it has to be produced to the magistrate, and all those things which is related to if the person runs away, then what happens. If you have arrested somebody and the person goes away, then what are the limitations or unlimited powers you got? Who can arrest with warrant, without warrant? All those things, every aspect related to arrest of a person is part of this particular section. So listen very, very carefully. This is a very, very important chapter, and it is very easy to get lost in such a chapter. Now, the sections are very written, very heavy and extensive. I'll take you through that so that next time when you read, it's very easy for you. So, section 41 is the first section which talks about when police may arrest without warrant. So, remember this section 41 listen very closely and very deeply, because a lot of further CRPC sections in this chapter would be referring to section 41 and 47. So when police may arrest without warrant. Now, there had been a change which was applicable from 1st November 2010, which has changed a lot of wordings in this particular chapter. It has also added a lot of new sections in this chapter, which were alphabetically added sections. These were also added depending upon the needs of either human right or a fair trial, or to preserve the right evidence, or to assist the victim, or to ensure the human right of both the victim and the accused. Now, when police may arrest without warrant, any police officer may, without an order from a magistrate and without a warrant, arrest a person A who commits in the presence of the police officer a cognizable offense. So, if you're a police officer, if you're seeing a cognizable offense, you're aware what are the cognizable offenses are. If it is happening in front of you, you could easily go and arrest that person. You don't need a warrant. You don't need even a complaint in advance for that. So you can go ahead and you can arrest that person. And this is something which is added as per the Amendment Act. Because prior to this, the wordings were different. Who has been concerned in any cognizable offense, or against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists, or his having been so concerned. So this was the earlier wordings, which has changed now, which was mostly helping the police to not do anything. Because the police would have come back and said, this is a very complex clause, and I can come back and say that I have not been informed. I don't have reasonable suspicion from past. So who has been in possession without lawful excuse, the burden of proving which executes. So this was very complicated earlier. You can read it. But now it is very straightforward. It says who commits in the presence of a police officer, a cognizable offense. So that's all is required as per section 41, 1, clause A. So any police officer can arrest in that situation. Number two, against whom a reasonable complaint has been made. So now you have made a complaint, received a complaint with a credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense when it was told to you and you were also aware. Punishable with imprisonment to term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied. Now, what are the additional conditions? Police has reason to believe, on the basis of such complaint, information, or suspicion that such person has committed the said offense. The police officer is satisfied that such arrest is necessary to prevent such person from committing any further offense, so committing any cognizable offense, and for proper investigation of the offenses, or to prevent such person from causing the evidence of the offense to disappear, or tampering with such evidence in any manner. So maybe somebody has seen somebody murdering somebody, and the person rushes to the nearby police station in the village or in a city and says, "I see somebody murdering 5 minutes back there." It's important for the police officer to immediately rush to the place and, without any written complaint, with this indication, go check, validate from his eyes, and if you see a murder happening, he should chase the person and arrest the person before the person disappears or tampers with the evidences. To prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from the disclosing such facts of the court or to the police officer. Or, as unless such person is arrested, his presence in the court whenever required cannot be ensured. that police officer and the police officer shall record while making such arrest his reason in writing. So nowadays it is with BNSS especially very much mandatory. So it was mandatory from CrPC perspective also, that if you are apprehending somebody, if you are arresting somebody, in that case you have to ensure that you are communicating the same to the uh, in writing to the court as well. So there should be a diary entry, there should be a reason filed why that person has been arrested, and it has to be filed into the relevant courts as well. Now, provided that a police officer shall, in all the cases where the arrest of a person is not required under provision of this subsection, record the reason in writing. So, what does it mean is, in spite of these reasons, if police officer still believes if none of the ingredients are present and still the person wants to arrest somebody, he or she can do that. But then there should be a reasonable reason in writing for why he has made that arrest or why he has not made that arrest. So, in either of the cases, the person has to make a writing. Now, against whom a credible information has been received that he has committed a cognizable offense punishable with imprisonment for a term which may extend to more than 7 years, whether with or without fine or with death sentence, and the police officer has reason to believe on the basis of that information that such person has committed the said offense. It's subclause of B only, C only. Now, who has been proclaimed as an offender under this code? So, proclaimed offenders are offenders who are known offenders and who have been committing crime multiple times of multiple variety or same variety in the same jurisdiction of police, and that those people could be arrested without a warrant if there is a complaint received against them, or the police officer has some reason or to believe that he is going to commit the same, in whose possession anything is found which may reasonably be suspected to be stolen property, or who may reasonably be suspected to having committed an offense with reference to such things, who obstructs a police officer while in the execution of his duty. Now, if the police officer has gone for some kind of execution of duty and somebody is prohibiting him, that person could be arrested, or who has escaped or attempt to escape from the lawful custody, or somebody was supposed to be arrested and has run away. So in both the cases, subclause E talks about that. F talks about who is reasonably suspected of being a deserter from any of the armed forces of the union. So somebody who has left the armed forces without intimating the armed forces, without going through the proper process of relief from the organization. If a deserter is found, that person also could be arrested because it's a matter of union's security. Now, the person who has concern in or against whom reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists of his having concern in any act committed at any place out of India, which is committed in India, would have been punishable as an offense, and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in India. So, either cases, if the person has committed a crime outside India, which could be considered a crime in India, or the person is under extradition, and the person, or for some reason, the person was legally supposed to be detained in the custody in India. In all such cases, the person could be, if found, be arrested immediately. And the clause H says, who being a released convict commits a breach of any rule made under subsection 5 of section 356, or for whose arrest any requisition, whether written or oral, has been received from another police officer. So, if a police officer says there is somebody in your area whom we are looking forward to arrest and he has committed so and so crime, a cognizable offense, the other police officer can arrest without warrant and hand it over to the other police officer. So, whether written or oral, either way, it is fine. Subject to the provision section 42, further you will come to know, no person concerned in a non-cognizable offense or against whom a complaint has been made or credible information has been received can be arrested. So, the person who against whom a non-cognizable offense has happened cannot be arrested until and unless a magistrate is approving that. So, without an approval from a magistrate, without an order from the magistrate, you cannot arrest such a person. There were some unnecessary clauses which were removed later while in 2000 this 2009 amendment. So those were removed. Those were giving some kind of confusion and unnecessary powers to the police. Those were removed. Now, if we come back to section 40, if we talk about summary of this particular section 40, what it talks about, the arrest can happen without warrant. A police officer can arrest without a warrant if a cognizable offense is committed in their presence. Then they can arrest on basis of suspicion as well, where they think reasonable uh, suspicion is there of the person or the persons committing cognizable offense. Punishment by imprisonment of less than 7 or equal to 7, up to 7 years, you can say. Now, there should be a justification of arrest under section 41, which is given, and the arrest is justified if it is necessary to prevent further offenses. That's the only reason you can do, or facilitate investigation, preserve the evidence, prevent witness tampering, or ensure the accused's court appearance. Now, arrest without warrant, a police officer can, of course, arrest, but there are other arrestable offenses also. For example, for the proclaimed offenders, individuals in possession of stolen property, obstructing police in their duties, escape from custody, suspected deserters, and individuals involved in extradition offenses. Record of reason for non-arrest has to be made if everything uh, is matching with the criteria, and then the police officer is not able to arrest that person. That has to be written. You see, the system has made a internally check system that in spite of all this, if the police officer for some reason, maybe his incompetence, or maybe his being, gratification was a case, if he or she is not doing his duty properly, then there is something which is already covered in the section 41, which says they have to definitely give in writing, present in writing, why it was not made. Arrest for a non-cognizable offenses can only happen if a magistrate says so. Otherwise, no. Arrest by police officer when the categories in section 109 or 110 is fulfilled under CrPC is deprecated now. So it is not required. 109, 1010 used to talk about the persons of shady character, if in that area, could be just arrested at any point of time, whom police might have considered a shady character. So that clause is removed. It has been far more accountability to the police on why you should arrest and why you should not arrest. And if you are not arresting when the person should have been arrested, you have to give in writing. Now, there are further four sections which we will talk, which is section 41A, B, C, and D. They were inserted in the code, and with the same amendment which was applicable from 1st of November 2010. And these four sections were very, very important for the sake of good, healthy legal system, crime management system, and regarding the um, human rights of both the victims and the accused. So 41A talks about notice of appearance before police officer. Now, you might have seen in multiple news in the newspaper as well, if you have noticed, and that sometime courts have raised their hands and they have come back and said to the police officers that, did you arrested the person, and were a notice of appearance was handed over to the police person for investigation before that? Was the person informed about what is being investigated against him? What are the cases against him? If not, this becomes a very strong case even for bail, and a lot of time the charges against the people have been also been quashed. There are cases, recent cases also, where FIR has also been quashed against such people because that was not done properly. So 41A notice is very, very important, where notice of appearance has to be given. The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received for a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. So you ask that person that credible information has been received for a reasonable suspicion against you for a cognizable offense. You come and meet me in so and so place, which could be mostly the police station or the police chowki. Number two, where such a notice is issued to any person, it shall be the duty of that person to then comply with the term of the notice. Now, if the person defaults, it's a problem to himself or herself. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice, unless, for reasons to be recorded by the police officer, is of the opinion that he ought to be arrested. So there might be a complaint against somebody that that person has killed five people, and the person has, kept their bodies in his refrigerator. Now, in that case, police can immediately go back and search the house. In that case, you cannot come back and say that the person is of clear criminal history and there is no such reason that could be that person might be doing that. Those are exceptional situations which you'll come to know further in this section. This is related to only sim offenses which could be which is something which is assumed by third party, which is reported to the police or suo moto picked up by the police. So you, until and unless do not have a reason for that person, when you bring that person to the police station, when you ask him 10 questions, when he leads you to certain more questions, when you ask, understand, check that with your own sources, and then if you believe the person has to be arrested, you can arrest. Otherwise, if he's complying, you cannot arrest. If he has come to the police station or the place you have asked him to come, the reasonable place, he can come or she can come and you can do that. Now, where such person at any time fails to comply with the terms of the notice, it shall be lawful for the police officer to arrest him for the offences mentioned in the notice subject. So, if he does not come, then you go and arrest. So, but if that such order has been passed on behalf of a competent court. So, the notice of appearance before police officer is a clause which was added in 2010. The purpose is to minimize unnecessary arrest and ensure that arrests are made only when absolutely necessary. And that goes by without saying to avoid the harassment. So this section mandates issuing a notice to a person to appear before a police officer if the arrest is not required. And the rationale to this is to protect individuals from arbitrary arrest, which is not very uncommon, especially in case involving offences punishable with imprisonment up to 7 years. So a fairness is also installed. Now come to the next section out of A, B, C, D. The second one is section 41B. So procedure of arrest and duties of officers making arrest. Now you had given a notice to the person, the procedures has been complied, and now you have arrested the person. It is required for the person to be arrested, or in 41 under 41(1) you have arrested somebody. In both the cases, you then follow section 41B, the procedure of arrest and the duties of officer making arrest. So every police officer while making an arrest, remember for under 41(1), 2 or 41A, they bear an accurate, visible and clear identification of his name which will facilitate easy identification. Now please understand, keep a habit as a student also, because you are a future lawyer, that the words are very valuable. So when you say bear an accurate, these are the points on which cases have failed. If I can come back and say here somebody's name was uh, Rajesh Ranjan Mato, okay, his name shows the same in Aadhaar card, his name shows in the PAN card, his name shows in all the records of the school and college. When I arrest the person, I by mistake as a police officer, I have added his name as Raj Kumar Mahto. This could be a ground where this whole FIR might be quashed as well, that it's a missing identification. This person is not the same person against whom the notices were issued or the credible information was received. So it is very, very important to put an accurate, visible. So when you write, it has to be clear and identification of his name, which will facilitate easy identification, because identification is a step mandated by CrPC to recognize that the right person is arrested and the matter is being run in the court, the trial is being run for that same person for it whom it was supposed to be running. Now prepare a memorandum of arrest. It's a proper form. If you see some point of time, it's a memorandum of arrest is a 4 or 5 pager document, big document, which talks about all the details about the person. And it has to be attested by at least one witness, whom we call the punch, who is a member of a family of the person arrested, or a punch, which is a respectable member of the locality where the arrest is made, countersigned by the person arrested. So as you are making a memorandum of arrest with all the details of the people, person, things on him, and all those things, a countersign for the person is very much required, so that he is also agreeing that yes, this was the condition, and inform the person arrested, unless the memorandum is attested by a member of his family, that he has a right to have a relative or a friend named by him to be informed. So if there is nobody, the person is being arrested in presence of a respectable member of the locality, which means there is no family or friend around. His person has a right where he can come back and ask police to inform about his arrest to one of the person of his choice. So this is 41B. So 41B is when the process of arrest starts, and this is to formalize the procedure for arrest and delineate the duties of the arresting officer, ensuring transparency and consistency. So this is also to maintain a proper record of the arrest of the person, of the conditions, and safeguard any unlawful detention. So this is why 41B was implemented. In the same series, 41C comes, which is control room at district. Now we have put procedure for arrest, we have put procedure for not arresting, we have put procedure for identifying the person, we have put procedure for arrest. Now control room and district. This was a very revolutionary thing where the state government shall establish a police control room in every district and every state level, and the state government shall cause to be displayed on the notice board kept outside the control room at every district, the names and address of the persons arrested and the name and designation of the police officer who made the arrest. Now, this is also available on Pune Police and Pimpri Police website. So it is available on most of the police websites. The control room at the police headquarters at the state level shall collect from time to time details about the persons arrested, nature of the offences which they are charged, and maintain a database for the information of the general public. And this is also reported to the central database. So this complete information is there. Plus, on top of that, every arrest which is made uh, under the non-bailable offense, a report has to be sent to the district magistrate as well on regular basis. So there is a arrest procedure. There is a first of all hurdle on whom you can arrest. If you have not arresting, what is the reason? Where you cannot arrest? When you arrest, what do you do? And then you maintain the complete record visible to the public eyes of all the people who are arrested and by whom and for what reason. So this brings in a solid transparency to enhance the tracking and monitoring of detention by common people also. So this is an accurate records are available to any person or person authorized by law to get further information. Finally, 41D, when you've arrested the person, information is shared, everything is done. What about the right of the arrested person to get the proper legal aid? Now, as law says, every person, whatever kind of crime he's accused of, that person has to definitely have um, uh, meet an advocate of his choice during interrogation. So the person, when they're arrested, he shall be or she shall be, I mean, in law, everybody is he, you know that, right? Shall be entitled to meet an advocate of his choice during interrogation, or this choice, if it is not there, the person can ask for a legal aid as well through the court. Now, not throughout the interrogation. So, throughout interrogation, probably not, but then start of interrogation and relevant part of interrogation when he could be made available without disturbing the interrogation and investigation, the person can have an advocate. It does not mean the advocate can sit next to him throughout the interrogation. It is not a law in India, it's a law in America. So but in India, the person can ask for somebody so that the person can brief him what to speak, what not to speak with the police, so that he understand and he is able to execute his rights for his getting free and fair legal advice. And once he's done with the questioning with the police, further again, he can, when out of action, he can again meet his advocate throughout the procedure going on. Now, this particular is 41D was a very good milestone in the in the eyes of law, because this allows arrested person the right to consult with a lawyer, which was not very clearly called out before that, which could have been a situation where a person considered who was not actually committed something might have suffered in the hands of law helplessly without getting a legal entitlement and no provision to help him to at the level of interrogation seek an advocate, which might be upfront declined by the police to the advocate or to the person. But this is possible because of 41D. You understand now 41 ABCD, how important this is from the perspective of actually conducting the arrest, reporting it, and doing it in a fair way with the taking care rights of all the people. Because the person is an accused. There are very some specific laws where the person is considered guilty, not accused. In those cases, it is little different because those are superseded by the procedures defined in those particular matters under those special acts. For example, POXO. So in POXO, the person is considered guilty. He is not considered an accused. So in such special cases, it's a bit different. Now, coming to section 42, arrest on refusal to give name and evidence. Now, when we talked about the NC, as we commonly say, non-cognizable offense, you have committed a non-cognizable offense listed under the BNS or IPC, and there is a complaint against you, and you are apprehended, you are brought into the police station, and you are coming and speaking with the police officers. But, or maybe you have been caught by a police officer on the street in a non-cognizable offense, and the police officer is speaking with you. In spite of this being a non-cognizable offense, how and why you could be arrested. So when any person who is presence of police officer has committed or has been accused of committing a non-cognizable offense, for example, you have gone and you have annoyed somebody, shouted on somebody, you have given curse word to somebody, and you have in the police officer is standing there, you're shouting and putting dirty curse word to a person. This is a non-cognizable offense. Police cannot arrest you. But at that point of time, if the officer says, I'm going to file an NC against you, you give me your name and your residence, address, and full details, whatever I'm asking. If you are not providing that to the officer, which automatically triggers what? You are obstructing the execution of the duty of the police officer. In that case, you qualify under that particular section and you could be arrested in spite of committing a non-cognizable offense, which is section 42(1) talks about. 2 is when the true name and residence of such person have been ascertained, he shall be released. So when the police officer asks your name and you say, my name is Aditya Kamble or my name is Ashok and I live in so-and-so society. So immediately when the police officer has all reasons to believe it is right, or the police officer wanted to check through somebody and he believes it is fine, so you might be released just not without anything also. You might be released on a bond of some amount also. You might be released with or without surety also, which is somebody on his name, somebody takes a guarantee that you will not run, and otherwise they will, they take a responsibility, or not even required to appear before a magistrate if so. Okay. Provided that if such person is not resident in India, the bond shall be secured by a surety or surety is residing in India. So if you are not an Indian in that case, but naturally a surety or the bond has to be coming from an Indian because we cannot have guarantee from a foreign land. Number 3, should the true name and the residence of such person not be ascertained within 24 hours from the time of arrest, or should he fail to execute the bond, or if so required to furnish sufficient surety, he shall forthwith be forwarded to the nearest magistrate. So then it becomes the process is executed as you have committed a cognizable offense, because now the police officer understands this is a non-cognizable offense. The police officer understands very well that you have given the name and address, but when he or she verified, he might have let you go. And if they find uh, that it is not correct and they have arrested you and they have asked you to furnish a bond or a surety, you're not doing that also. In that case, if you're not comply with either of them, then you will be forwarded to the magistrate, as is done in case of the warrant arrest. So what are the key takeaways from this particular section is arrest for refusal to identify can happen in case of non-cognizable offense. Release has to be done after identification of the person, name and the address, or supply of a surety or bond. And a non-resident, a surety has to come from a resident from India. Now coming to section 43. Arrest by private person and procedure on such arrest. Now, this is different than what we earlier seen, right? See, earlier, chapter 4, it was aiding the arrest. A warrant has been issued and you are supposed to execute it. Or you are aiding a police officer or a magistrate to arrest somebody. In this case, you yourself as a private person is trying to arrest somebody when you can do and how you should do and what you should do. So any private person may arrest or cause to be arrested by any person who in his presence commits a non-bailable and cognizable offense. So if you know what is a non-bailable and cognizable offense, if you have seen that have been committed in front of you, or any proclaimed offender, we said what is a proclaimed offender, right? The offender who is habitual offender and without unnecessary delay shall make over a cause to be made over any person so arrested to a police officer. or in the absence of a police officer, take them to a nearest police station. So you can arrest if somebody murders somebody in front of you or somebody rapes somebody. It is simply allowed to those people or that person or persons to arrest that person, and following all the right measures of not hurting the person unnecessarily, not causing the death or risk to his death, you can hand over it to the police officer or a police station. You have to take it, the person, and hand it over. Now, if there is a reason to believe that such person comes under the provision of Section 41, a police officer shall rearrest him. In case the police officer is around, or the police station, when you take the person to the police station, and the police officer there believes that this person is somebody under Section 41, all the clauses which were applicable, if he is the person comes under those provision, that person will be arrested. If there is no reason to believe, because either of the two can happen, either the police officer believes that person could be arrested, or could not believe the person could be arrested, so has committed a non-cognizable offense, and he refuses on demand of a police officer to give his name and residence. Now, same thing happens. Now, it is believed that a non-cognizable offense has happened, not a cognizable offense, but still that person, when brought to the police officer, is not disclosing his name or resident address or giving name or residence, then Section 42 is applicable. The person could be again arrested according to Section 42. Okay. So this is talking about the citizen's power of arrest. This talks about the duty when you arrest somebody, and this talks about then the police officer's discretion on arresting upfront or considering it as a non-cognizable and treating it in accordance with Section 42. Section 44, which is an arrest by magistrate. So both executive magistrate and the judicial magistrate, we spoke about both of them yesterday. So the executive magistrates are magistrates which are having primary duty of running the administration. For example, I mentioned yesterday district magistrate, ADM, SDM, or any such special magistrate, special executive magistrate, plus any judicial magistrate which is in the courts. When an offense is committed in presence of a magistrate, either of them, executive or judicial, within his local jurisdiction. So the power is within his local jurisdiction, first, defined in Section 44(1) clause. He may himself arrest, if capable, or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. So automatically the previous 43, 42, 41, everything is applicable the way arrest has to happen. While subclause 44, subclause 2 says any magistrate, either executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. So sometimes special officers, special judicial magistrates, etc. are there who can order a direct, or for example, in case of non-cognizable offenses, Section 44(2) is used where the magistrate can ask for an arrest for that person under 44(2). So this is how Section 44 talks about arrests by magistrate. And the key provisions, what is there is about the authority. The authority is of both the kinds of magistrate. Commitment to the custody is that the magistrate can commit the offender to custody, which must be conducted in accordance with the previous, all the provisions we have discussed, 41, 42, or 43. And the purpose is always only because either to maintain the law and order, or either which is allowed as per the provision of the, and is in the hands of that particular jurisdiction of the magistrate to do that. But please understand, he or she can only order within his local jurisdiction. It cannot happen outside his local jurisdiction. If it is outside his local jurisdiction, he or she has to take help of the local executive magistrate or the judicial magistrate or the local police officer, and then according to the sections in CrPC, for the police officer to arrest, or a police officer by intimated by other police officer an arrest, those clauses are automatically invoked. So you understand, all of these are inbuilt and interwoven. All the sections act not in silo. All of them acts at some point of time are also working in connection with each other. So this is about Section 44 And then let's go to section 45. Now, when we are talking about arrest, procedure, responsibilities, etc., there is one group of people who are the member of armed forces. Now, there is a special protection in the eyes of law given in the Union of India, or in fact in all the countries, to the armed forces, where the consequences in line of duty, if something happens, is something which is taken, the guilt is taken by the union, whether central government or the state government. It is not, the guilt is not on the individual. The guilt transfers to the state. So notwithstanding anything contained in section 41 to 44, both inclusive, no member of the armed forces of the union shall be arrested for anything done or purported to be done by him in discharge of his official duties, except after obtaining the consent of the central government. So they cannot be arrested for anything done in the line of duty. The state government may by notification direct that the provisions of subsection 1 shall apply to such class or category of the members of the force charged with the maintenance of public order as may be specified therein. Wherever they may be serving, thereupon the provisions of the subsection shall apply as if the expression central government occurring therein, the expression state. So it simply means if the said force is related to that particular state government, not the central government, in that case also it should be read as if it is something which is upon the state government, rather than the individual himself or herself. So a forces which is reporting to the central government or the state government, either way, it means in summary, the accountability, the legal liability is transferred automatically to the state government or the central government accordingly, and not onto the shoulders of those individuals. Now, what are the special things about Section 45 is this is a general rule. The members of the armed forces of Union cannot be arrested for actions taken in the discharge of their duty. Now, they might be doing a discharge of duty against terrorist attack in a city. They might be doing something against, some army have infiltrated in the region. And while discharge of the duty, they might have committed something which might have hurt somebody, some kind of grievous hurt has happened in line of duty. The burden is not on the individual. The protection exists to any action performed by the armed forces during their official duties. Now, during their official duties. So it is not that if an armed force personnel who was not in the line of duty and commits something, then they are not immune. Now, state government authorization is part of the subsection 2, which looks like 3 here. I don't know, I'm not able to change it. So state government notification and the central government notification, if they come back and notify something specially against that, then otherwise every central gadget around this has to be read as replaced by the word center to state in that case. Why this is done is to give an operational independence to such forces, because if forces in line of duty within the civilian areas, if they commit something which happens by a side effect of their act, what they're doing in those jurisdictions of the private people, they get distracted. So they have to be completely focused on their activities, and this hindrance has to be kept apart from their operational excellence. So that is why operational independence is given. So this provision primarily applies to the personnel of armed forces only. And overall, this embodies the legal protection offered to the member of the armed forces. Now we have seen this procedure of arrest. So this is 41V, where we talk about the technicalities while arresting. Now, the next section, I just scrolled up so that you are not confused between section 46 and that particular section. So section 46 talks about how arrest has to be made. Now, that was talking about the procedures there, but now this is between the police and the person being arrested. So, in making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested unless there be a submission to the custody by word of action. If I come back and say you get arrested, you come sit here, it is fine. No handcuff, no physical touch, no manhandling is required. But if you're not going by the legal words and you're not submitting to the custody by the word, then it can happen. Provided that when a woman is arrested, unless the circumstances indicate to the contrary, her submission to the custody on an oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the person of the woman for making her arrest. So, unless it is contrary, for example, you have gone to arrest Fulan Devi, in that case, you will not expect that she will be docile enough to come back and you say, come in my custody and she will come and sit. So, in such scenarios where the person is known to be hostile and probably for some reason believe the person has to be physically taken in under control, in those cases, yes. Otherwise, it is presumed that the arrest can only happen via oral intimation to that particular lady. And if at any cost it is required to be done so, you need to ensure that person is touched by only a lady police officer, not a male police officer. Section 46 subclause 2 says if such person forcibly resists the endeavor to arrest him or attempts to evade the arrest, male or female, such police officer or other person may use all antics necessary to effect the arrest. So all means which are required to be done to ensure the arrest. Number 3 says nothing in this section gives a right to cause the death of the person. Now, it has to be reasonable. So by any means, it does not say you put a rope in the neck of the person and you are tying him or her on the road, dragging him on the road, and the person dies in the consequence. Or you get into such a fight or you injure him with a gun or with a knife or with some rod or something, some tool, which causes the death of the person who is not accused of an offense punishable with death or with imprisonment of life. So nothing in this section gives a right to cause the death of a person who is not accused of an offense punishable with death or with imprisonment of life. Read it reverse as well. So in case there is a death or deaths happen from somebody, in that case, the person is considered max hostile. The person could be considered very, very dangerous, but it is all very subjective. Because back of mind, a police officer should always understand he or she is answerable. So probably if somebody, these things are not very uncommon nowadays. We see in the newspaper as well. Husband and wife, a death is caused because of some reason. Either of them kills either of them. In that case, with Section 3, using subclause 3, if the police officer goes there, will he be left unhurt in the hands of the law if he says, boss, that person has caused a death and by scuffle I've killed that person and he is anyways an accused in offense or punishable with death or imprisonment of life and I killed him, it's not a problem. No, it means these sentences in the acts and the laws are written black and white, but the interpretations are always subjective. So it has to be really necessary and it might be of that extent a risk where a death might have happened. For example, you are apprehending, you are going ahead and you can trying to arrest a criminal, which is who have committed dacoity, and you are chasing those people to arrest those people, and those people are counter firing on you. In that case, if there is a known criminal who is a serial killer, there is a person who has killed 10 different people, a person who is a history cheater. In those cases, if there is a chance of self-defense by the police officer, and that can be proved, then only Section 46 subclause 3 is applicable, otherwise not. Number 4, save in exceptional circumstances, no women shall be arrested after sunset and before sunrise. I think everybody knows this. And where such exceptional circumstances exist, the women police officer shall, by making a written report, obtain prior permission of the judicial magistrate of the first class, within whose local jurisdiction the offense is committed or the arrest is to be made. So, Section 46 talks about it's around, do you really need to touch or confine that person, and in what conditions you can go up to shoot that person or kill that person. So in order to make a lawful arrest, the person should be first be asked to surrender, and come into the custody, give a consent. Otherwise, a physical touch is allowed or confinement is allowed. Confinement means tying him or putting him in some room or box. Submission to the custody is another element of this section where the if the person accused being arrested voluntarily submits or not, and there are special provisions for women during the arrest or in case of how to arrest if they have become hostile. Use of force has to be justified in all the cases until the force which has caused a death, and it has to be reasonable, and there is no right to cause death preliminary, but in exceptional situations it could be considered. But for the capital punishment or life imprisonment cases, it is allowed, and that right is given to the police, but it is not an open right. It has to be justified. The timing of arrest around the women uh, is limited. In case it is very strongly believed, it is very much required at the late hours after the sunrise and sunset. If you see now the BNSS, it is given the time as so and so AM and PM. It's not sunrise sunset given now anymore, which was something which was not very clear. Requirements for permission is very much required in certain cases, and the objective of this particular section is nothing but protection of the dignity of the person being arrested, clarity in the procedure, preventing an abuse of force or causing death. These are the three very key elements which are there for section 46 about arrest how to made. Coming to section 47, search of the place entered by person sought to be arrested. Now, I told you at the very start of the session, remember section 41 and 47 too. We'll refer to it later also. So, section 47 talks about search of place entered by person sought to be arrested. So, a person has to be arrested and he has entered a place where I have to go, and as a police officer or a law enforcement agency, I have to go and enter that place and to make an arrest of this person. This is a very common thing which happens for a lot of criminals who are running away from the hands of the police or the law enforcement agencies, either kind of criminals, all kind of criminals. The search of the place has to be done where the person has entered and hidden himself or herself, who are supposed to be arrested. Now, section 47 clause 1 says, if any person acting under a warrant of arrest, 41, or any police officer having authority to arrest has reasons to believe that the person to be arrested has entered into or is within any place, any person residing in or being in charge of such place shall, on demand of such person, acting as aforesaid on such police officer, allow him free ingress thereto, and afford all reasonable facilities for such therein. So this is something which is duty of the person who is in charge of that particular residence or vicinity. If he or she has got a key or a code word to get the access to that place, or has to provide a map of that place, or has to provide all the entry and exit locations to the police officer, it is inbound duty of that particular person or persons to ensure that is given to the police officer who has come to search that place to find and arrest that person. Number two, clause number two says, if ingress to such place cannot be obtained, so if the person is not allowing or has not got the key, the owner of the person, the place, or the owner of the place is not there at all, which is in subsection 1, it shall be lawful in any case for a person acting under a warrant. Now, acting under a warrant is a police officer and a non-police officer also, because the law here looks from warrant perspective. Who is holding the warrant is the police officer. As I said earlier in the previous section also, if there is a warrant in hands of a common person, private person also, that person is acts like a police. So this is applicable to that person also. So in it is lawful for any case for a person acting under a warrant, and in case in which a warrant may issue but cannot be obtained without affording the a person to be arrested an opportunity to escape for a police officer to enter such place and search therein, in order to effect an entrance into such place, they can break open any outer or inner door or window or of any house or place. Door and window they can break. Any door and window they can break. They can break the main gate, main door, security door, or any inside door like bedroom door, bathroom door, anything is allowed, or window, whether that of the person to be arrested or of any other person. So it doesn't matter that the house where the police is breaking the door and window, etc., is belonging to somebody else. It's not that it has to be always with for accused own owned place that he or she or the police officer can break the door and window. If after notification of his authority and purposes and demand of admittance duly made, he cannot otherwise obtain admittance. So how you can produce the authority? You can produce the authority to the owner of that vicinity or the controller of that vicinity. You can ask their support to enter, to facilitate your entry safely and securing all the exit points, or you can make an announcement verbally or through a phone or a microphone or a speaker that you come and surrender. In case he or she is not doing still, 47(2) allows you to break door windows at any level and go inside and secure that person is arrested. Provided that if such place is an apartment in the actual occupancy of a female and not being the person to be arrested, who according to custom does not appear in public. For example, a pardanashi. Such person or police officer shall, before entering such apartment, give notice to such female also that she is at liberty to withdraw and shall afford her every reasonable facility for withdrawing and may then break open the apartment and enter it. So give an opportunity. But the other way around, law also checks and control the person also, where then based on the previous clause, the person becomes culpable to particular crime committed by the person because he or she has not aided the police officer in entering the premises. So in that case, the person becomes herself or a culprit. Subclause 3 says any police officer or other person authorized to make an arrest may break open any outer or inner door or window of any house or place in order to liberate himself or any other person who, having lawfully entered for the purpose of making arrest, is detained therein. So a police officer goes inside and somebody locks the door from outside and runs away. So if he has got some team there to help, they may come back and open the door. If for some reason nobody is there and he's not able to break it, he might use a firearm also to break the door and come out. It is allowed. That's not problem. And even if somebody who is kept inside their premises, when he has gone there, he has found that person is confined unlawfully, he can break the door, open the window, break the window, whatever he can do, and he can still release the person, irrespective of the place being owned by accused or not. So basically, what this section says is this is an authority to search by the police officer or the person holding the warrant, if we can say more rightly. So whether it's a private person or a person holding the warrant, warrant empowers. In this case, you can understand warrant empowers the hands of the police officer, who is the most appropriate person to execute the warrant, but it does empowers equally the common person, the private person who is holding the warrant. So warrant has got that power to get the entry. So with warrant in hand, you have an authority to search, and if a person acts under a warrant as a police officer, he has believe all reasons to believe the person is inside and is not coming out. He can take help, but there is an obligation of the other residents also to support him, and he can enter by force also when the ingress, which is entry, is denied. Breaking and entering can also be done. Notification is required if there is a pardanashi inside, or for some reason, some custom, some other religion also, the ladies, females are not allowed to be in open, or they don't prefer to be in open. Special provision regarding women's are given and women are given, and breaking open in self-defense if they are trapped inside or to liberate somebody else is also allowed. So what is the objective of this particular section is it ensures an effective law enforcement while making an arrest and while finding. It balances the rights and the law enforcement. So it is not balancing the only the right of the people around that or the accused or the victim. It is also balancing the law enforcement, because in balancing act of the rights, it should not happen that the law and order becomes ineffective, and preventing of evasion. So it is very important that for any trial or anything, you need to have the person to be present to be tried and punished in case the person is found to be guilty. So in that case, this also helps in prevention of an evasion, which is a very important ingredient in the machinery of the justice of delivery of justice in case of the criminal law or any law. So Now we come to section 48. Pursuit of offenders into other jurisdiction. A police officer may, for the purpose of arresting without warrant, any person whom he is authorized to arrest, pursue such person into any place in India. So under section 48 only, police goes to different cities and they can find and arrest those people. There are certain police manual and rules around that, where how they have to inform the local police, in what situations they can arrest, in what situations they cannot enter certain premises. But there are exceptions as well, where they sometimes need not inform the local police also to bring in the culprit. But then there are certain procedures you will see in further in CrPC only, where while bringing a person from a different state to a different state, there is a procedure which has to be followed, and there is an order which has to be obtained from the judicial magistrate, so that an illegal transfer of people for a forceful implementation of law does not happen, whatever be the category of the crime the person has done. Coming to see the key provisions for section 48. So this gives a access to the police officers across the country. It's a geographical flexibility which is given. The term is geographical flexibility, which is given to the police under section 48. It is an effective law enforcement. It is a prevention of evasion again, and it's an uniform application of law irrespective of being cross jurisdictional pursuits. Section 49 talks about no unnecessary restraint. A person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Now, post independence, when the police was functioning, there was a old culture with the British Raj, or previous to that as well, there were invasions in India. So that culture was to the police being very brutal, because the police was not made to work for the citizen to manage the law and order, that was managed to suppress the people and suppress the Indians, basically. So there was no standard maintained for restraint. Now, if you see nowadays, most of the time, if there is a production in open, then only a handcuff is put to the criminal. Otherwise, they do not put handcuff also. It is not even allowed that way. But earlier days, it was they were restrained, and there are certain scenarios in some cities in India also, where they have been tied with a lot of ropes, steel chains, and all those things used to happen. So section 49 came back and says no unnecessary restraint. What is the purpose of restraining somebody? Is the person is not escaping the hands of the law, and you use only that particular limited restraint. So the section says the limitation has to be in terms of restraint on need basis and protecting the dignity of the person also. What if tomorrow that person does not comes out to be the guilty person? So there should not be an opportunity lost to ensure the dignity of the person is not lost. And then, of course, upholding the human rights, which is at the national and the international level, we have different obligations as a government. Preventing of abuse of power, because at times this restraint is not only just because of restraint. This might be an abuse of power by the police officer. They are showing his courage and his might. They might do certain things which might be unnecessary. And this includes, beating, thrashing, breaking the bones of the leg, etc., shooting the person, making him lame, incapable to run. If it is not required, don't do it. Encouragement of professional conduct, which sum totals to be a professional behavior of the police, and the guidelines of the law agreement enforcement and the legal recourse is also necessary element which defines section 49. Coming to section 50, we have 10 more sections left. Section 50, we have person arrested to be informed of grounds of arrest and of right to bail. Now, every police officer or the other person arresting any person without warrant shall forthwith communicate to him full particulars of the offences for which he is arrested or other grounds for such arrest, and whether a police officer arrests without warrant any person other than a person accused of a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. So the person arrested to be definitely informed of the ground of arrest. Nowadays, it has become very much mandatory in the courts nowadays, where the judges definitely ask. I mean, it used to happen earlier also, but now it is very much prevalent. Even during trial, they ask that were you made aware of the charges against you? Were you treated well with the police? Were you told that there is a bail option which you can avail? Is it possible? Was it told to you that you can avail legal aid in case you do not have a lawyer standing for you? So it is an immediate notification which is mandated by CRPC Section 50, that a notification has to be immediate. Any police officer or person effectuating the arrest must immediately inform the arrested individual. So it is not a might right of the police officer to arrest somebody and forget about it, putting him in the back of the jeep and go to the police station, putting him in the behind the bars, and the things are done. No, it looks for more professional approach of the police, because what we believe more from the legal justice perspective in India now and across the world also is the law of natural justice. We want the perspective of the arrest, the perspective of the criminal justice is not to primarily punish the person. As the Supreme Court very famously they say, the bail is the rule, jail is exception. So if you're treating the people unfair, if you're treating the people without giving them opportunity to come back and contest for their own side, their own sake, it becomes very wrong and it's very difficult to uphold the natural justice of law. And that is why, in light of that, Section 50 says that every police officer or other person, in case you become a police officer for time being executing a warrant, arresting any person without warrant, shall forthwith communicate him full particulars. So information about the bail you have to give, an opportunity to arrange surety. You cannot block him to arrange from any surety. If required, he can communicate that also. Then awareness of the legal right has to be given, because if we have to, at the end, the result is to avail no the bail as the rule and jail as an exception, and we have to uphold the natural law of natural justice. The awareness of the legal right has to be given to the person, and preventing arbitrary detention. So any arbitrary detention, if the person is not aware of the legal process, is not getting a legal aid, is not able to give a surety, is not able to arrange for a bail for himself, it's an arbitrary detention. Normally, in such cases, if police arrest somebody, they are given at least 2, 3 opportunities via 2, 3 hearings. And if they are not able to prove why that person should be under their detention or should be forwarded to the jail, uh, in case of a non-bailable offense also, default bail is provided to the person. So this is facilitating a legal protection to everybody. So relevance is the arrest situation and the legal implication in case the such facility is not given to the person arrested. While Section 50A talks about obligation of person making arrest to inform about the arrest, etc., to nominated person. Now, the first one, 50, is talking about the arrest of the person and informing him, letting him arrange for his own release, letting him arrange for his surety, letting him contest his bail application, letting him know what exactly has happened, which offenses under which he is arrested, and all those grounds of such arrested. While 50A, which was added later, was a very important addition to this, is in a condition where the person, if was isolated from the family, near dear ones and friends, in that case, in isolation, the person was arrested. How would somebody in his family would know? And of course, a family and friend is a very essential support in those situations where they need the legal system to run effectively towards that particular accused or the arrest person. And for that, it is the obligation of the person making arrest. Now, in this case, there is a slight difference when you work as a private person and arrest, and when a police officer arrested. The moment you arrest, you have the rights of arresting, which is powers and security of a police officer. But Section 50 and 50 is not applicable on you. Section 50 and 50A is automatically transferred to the police officer to whom you were handed over, or to the police station and the in charge where you have handed over. So 50 and 50A is not applicable mostly to the person who is arresting as a private person. As a private person, you are not obliged to go back under Section 50A and inform his family member or somebody, call him or her and inform about his arrest. That is not required. So 50A, every police officer or other person making an arrest, other person here is some other magistrate, under this code shall forthwith give the information regarding such arrest and place where the arrest person is being held to any of his friend, relative, or such other person he may disclosed or nominated by the arrested person for the purpose of giving such information. So if you have picked up the person from in between the family or the friends, need not do that. But in case it has done in isolation, you have to supposed to do that. The police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. So they come back and say, hey, we have arrested you, and this is an obligation for us to inform somebody. Tell me, whom should I inform? So immediately you have to done. So these things have to be done immediately, like the previous clause, previous section, it has to be done immediately. The police officer shall inform, and then entry of the fact as to who has been informed of the arrest of such person shall be made in the book of to be kept in the police station in such form as may be prescribed in this behalf by the state government, which is the diary. The police station diary, there has to be an entry made, the person when he was brought, and all the records has to be created about what time he was brought in, what is his particular home address, etc., and then whom it was informed, the next kin or the next friend, family, whomsoever it is. So it shall be the duty of the magistrate before whom the such arrested person is produced to satisfy himself that requirements of 2, 3 has been complied with in respect of such arrested person. So it is very, very important that the person was informed and the entry was also made in the diary entry that has to be seen by the magistrate. Now, in many cases, this becomes a case for seeking bail as well. Because these were not completely properly done, complied with. So why this section 50A is there? Section 50A is, first of all, protection of the personal liberty, which is right of every person standing in India. So they have a protection of personal liberty. This is a right even given to a foreigner standing on the soil of India. So protection of personal liberty is done through this 50A, prevention of custodial abuse. It is possible that in everybody's unawareness, you have arrested somebody and then you have made that person be in the custody and you do whatever you want with him. It's not right. So to stop a custodial abuse, if you have already informed somebody, you are aware that somebody is going to come and look for that person. So the abuse automatically becomes lower. Promoting a transparency, because the law talks about equity, the equal chances to all the parties. So this brings up equity and transparency. And facilitating legal representation. It is mandated by the constitution and by various laws that, and various rules also, that everybody has a legal representation right, whether free or paid. And alignment with the human rights standards. That is something which reflects very bad on the country also. So it's an alignment with the human rights also. So the key provisions are: notification is required, a nominated person is required, information informing the arrest person about their right is required, documentation is required in the police station about what they have, whom they have approached. Oversight role of the magistrate is also defined as part of the uh, clause 4, where there is quite a chance the police officers might not do what is prescribed, which is common. In that case, oversight of a magistrate is also very much required. So the overall objective is to enhance the personal liberty, transparency, accountability, facilitate the legal representation and oversight mechanism to be established. So section 50A was bring in as a oversight mechanism and bring in the right liberty to the person. Coming to section 51. Now, search of arrested persons. Now, when a person is arrested by a police officer under a warrant which does not provide for the taking of bail, which is non-bailable offense, or under a warrant which provides for the taking of bail, but the person arrested cannot furnish a bail. So he or she has not arranged for a bail for himself. And whenever a person is arrested without warrant or by private person under a warrant and cannot legally be admitted to bail or is unable to furnish bail, the officer making the arrest, or when the arrest is made by the private person, the police officer to whom he makes over the person arrested may search such person and place in safe custody all articles. What is in the pocket, what is in the jeans pocket, what is in the front pocket, what jewelry he or she is wearing, what necessary wearing apparel, what are there, found upon him, and where any article is seized from the arrested person, receipt showing the article taken in possession by the police officer shall be given to such person. It is also signed by the person. So if as a private person arrests, they cannot do that. They have to hand over to the police officer, and the police officer's responsibility is to do that. Whenever it is necessary to cause a female to be searched, the search shall be made by another female with strict regard to decency. So this automatically applies. It has to be done up to the level it is required to be done. So section 51 is about the search in person of the person. So it says the applicable circumstances could be varied. It could be by a police officer under a warrant for a bailable, non-bailable offense. It could be under a warrant that allows for bail, but bail has not been furnished. When a person is arrested without a warrant, for a cognizable offense, or in case of a non-cognizable offense where the person has not disclosed his name and address, or by a private individual like you who who is executing a warrant, but then it has to be handed over this responsibility to the police officer. When the person's responsibility is not there, once it is done, hand over, the police immediately has to then do the search. Now, when you search, the authority of search is there, but for a female, it has to be a female, not a male. And what items has to be collected has to be listed out, and it has to be put in a safe custody until and unless you find something which is a contraband or an arm. So everything has to be uh, listed out. In fact, those things also has to be listed out, but then those are not stored. Objectives and rationale around this is for safety and security, because the person might have something harmful to harm himself, herself, or to the police or to the magistrate or to, in future, people coming in contact with that person. Preservation of evidence. This will also might bring in some evidence. If there is a person arrested at the matka for matka or that kind of gambling, and you find a lot of chits in his pocket, that becomes one of the evidence. If the person is arrested under consumption of narcotics, and you find on his person or her person drugs, that becomes an evidence. If the person is a gangster, or a person who is arrested in general for anything, and an arm is found which is lethal and which is not licensed, that also becomes an evidence towards the conduct and the character of the person. So preservation of evidence also happens, protecting the personal right also. So in a way, we are also protecting the right, because whatever they have got, it is their in-person thing. It should not be lost. It should be handed over back to the person. It has to be safeguarded and stored properly, and regulate the police conduct also, because the police also should ensure and respect whatever is in person of the person. So search protocol is there. Legal accountability is also equally built in this particular section. Coming to section 52, power to seize offensive weapons. Now, the officer or other person making any arrest under this code may take in from person arrested any offensive weapons which he has about his person, and shall deliver all weapons so taken to the court or officer before which or whom the officer or person making the arrest is required by this code to produce the person arrested. So it is an authority to seize given to the police officer, which is very necessary ingredient by all common sense and means. The offensive weapons has to be definitely, the police has to be authorized to seize it, and the scope of seizure is all the offensive. And there are certain parameters given via different government gadgets about the size of the knife, the type of the knife, the type of the dagger, the type of the gun, where it's an air gun or it's a certain caliber explosive gun. So all those things are, it's a bomb which is a Diwali bomb, or it's a serious bomb, it's a petrol bomb, it's a Shortesky bomb. So whatever it is, the lists are given to the police, and based upon that, they decide what is offensive, what is not offensive. So through that checklist, police is normally aware of that. There is a mandatory reporting which is included. So it is connected with section 51, 52. When 51 in person you find, you have already created a list. In that list, this 52 power seize offensive weapon is also showing. So it is already documented there. This is ensuring safety, preventing escalation of violence also. The person, if in person of such offensive weapon, might create violence also. And it creates a legal accountability also, to ensure you are showing the conduct and the character of the person. So conduct the search and document the seize is what is guided by this particular section. Section 53 talks about examination of accused by medical practitioner at the request of police officer. Now, it is by law. If you read this, I'll tell you first the section, then I'll tell you what happens exactly. So, clause 1 says when a person is arrested on a charge of committing any offense, actually, of such a nature and alleged to have been committed under such circumstances that there is a reasonable ground for believing that an examination of his person will afford evidence as to commission of an offense, it shall be lawful for a registered medical practitioner acting at the request of a police officer not below the rank of sub inspector and for any person acting in good faith in his aid and under his direction to make such examination of the person arrested as is reasonable necessary in order to ascertain the facts which may afford such evidence and to use such force as it reasonably necessary for that purpose. Now, there are multiple very important keywords in this. When a person is arrested on charge of committing any offense of such a nature, now it is written by book for such a nature where it might be required to evaluate the health of that person, to understand the injury of the person, for example, to collect the blood sample and further other biological samples of the person. But in general, it is prescribed to, for any offense, if there is an arrest made, there is a medical test which has to be done. The reason being two things. One is you might discover something which is not visible to the plain eyes because you are seeing somebody in proper attire, clothes, and with a eyes to the outer body. But a doctor, when examines, they can come back and find something. Second thing, the person might be suffering from something which might need immediate attention so that he could be produced for overall for the legal process and the trial going ahead, and he is not, we do not lose that person. So that is something which is very, very important to ensure the person is hale and hearty, and his, even if he is not healthy, that condition is also recorded so that tomorrow the situation when it escalates, it doesn't not come back that it has happened in the custody. It was available before the custody. It was impacting him before that. That there is a reasonable ground for believing that an examination of this person will afford evidence, it shall be lawful for a registered medical practitioner is completely defined as per certain medical acts, which we will mention further, acting at the request of a police officer. So it has to be initiated by a police officer and not below the rank of sub-inspector. So ideally a sub-inspector. Now, 80% of the police force is constabulary. Constabulary means the junior most constable up to single star ASI. That is constabulary. So 80% is constabulary, then sub-inspector comes. So we have a very few number of officers at the rank of sub-inspector, inspector, senior inspector. In that case, it is not possible always, so that it is also written that and for any person acting in good faith in his aid, which is mostly the police constables. So this is authorized by the police sub at the rank of sub-inspector at least, but it is executed by the person in good faith, which is the constables of the police station under his direction to make such examination of the person arrested as in reasonably necessary in order to ascertain. So you will, the basic tests are defined already. Those tests are reasonably done. And so use such force reasonably necessary for that. Now, there might be a condition where the accused is not ready to go to the doctor. For some reason, he or she believes it's not safe. It will help him in his legal remedy or whatever so it has to be. In that case, it is allowed to put a reasonable force where people can catch him, put him in a vehicle, hold him, take him, produce him to the doctor, make him aware and appear in front of the doctor for conducting all the necessary tests, cooperate for the all the necessary tests and examination. That is the only level of force which is required. And whatever the person, whenever the person of female is to be examined, the examination shall be made only by or under the supervision of a female registered medical practitioner. And for that sake, the constable or the police officer is also female. And examination shall include examination of blood, blood stains, semen swabs in case of sexual offenses, sputum, sweat, hair sample, finger, nail clipping of use of modern and scientific techniques, DNA profiling if required, and other tests which is registered medical practitioner thinks necessary. Normally, it's a visible check also of the body, X-ray of the chest to see if there is a tuberculosis, examination of the rectum, examination of the private parts. Registered medical practitioner, as I said, is as per the state medical register under MCA, Medical Council Act. And in the section 2H of the Medical Council Act, it's not part of the Bare Act, it's not there, is prescribed means prescribed by regulation. So a question may come saying registered medical practitioner, why it has to be going to a certain government hospital only, not to any other medical practitioner? Why police does not take that? So why they are not taking that? Because the people on Medical Council Act, the people who are registered on the state roll are all eligible. No, this is not the case, because you have to read very clearly is who possesses any medical qualification as defined in clause H. Clause H means prescribed, means by regulation. So although he is registered, he is qualified, but is he prescribed consultant? So prescribed list of consultant is given by center and state through the gadget they publish. They notify certain hospitals, government hospitals, to ascertain the quality and to ensure there is a control. So that is why not every doctor is allowed to conduct this. So this basis of examination is the person arrested for charge are reasonable ground to believe that the person, whoever is brought in, is tested properly. His examination is done by a medical practitioner to ensure his health. His condition is frozen in time on record. A gender sensitive approach is prescribed already in the section. Definition talks about certain basic tests, although this is not limited to that. This is subject to the gadget published by the state in direction with the central government. Definition of the registered medical practitioner is beyond being on the register and qualified. It has to be prescribed by the state as well. And the objective of this section is to first primarily facilitate evidence collection, because it says on certain reasons. Legal framework for medical procedure is given, and protection of women's right is also taken care in this. This helps in the criminal investigation as well. So this is section 53. Now 53A has been brought in as a addition to, it was not non-existent before 2010, and this has come focused on the sexual offenses. So examination of a person accused of a rape by medical practitioner. See, there is no comma in the Bare Act. It makes two different meanings. So examination of person accused of rape by medical practitioner is actually examination of person accused of rape by a medical practitioner. Okay, so it makes two different meanings. So number one, when a person is arrested on a charge of committing an offense of rape or an attempt to commit rape, and there are reasonable grounds for believing that an examination of this person will afford evidence as to commission of such offenses, it shall be lawful for the registered medical practitioner employed in a hospital run by the government or by a local authority, and in the absence of such practitioner within the radius of 16 kilometers from the place where the offense has been committed by any other registered medical practitioner. She can also go by herself also on the first instance, acting at the request of a police officer not below the rank of sub-inspector, same recipe, and for any person acting in good faith in his aid, which is the constable normally, under his direction, to make such examination of the arrested person and to use such force as is reasonably necessary for that purpose. This force is mostly not required to be put on the victim itself. It might be required if somebody is resisting the victim to not be medically tested and the victim is wanting to get that done. The registered medical practitioner conducting such examination shall without delay examine such person and prepare a report of his examination giving the following particular. Now, the name and address of the accused and of the person by whom he was brought, the age of the accused, marks of injury, if any, on the person of the accused, the description of material taken from the person of the accused for DNA profiling, and other material particulars in reasonable detail. So this is all taken for accused of rape. The report shall state precisely the reason for each conclusion arrived at, and the exact time of commencement and completion of the examination shall also be noted in the report. The registered medical practitioner shall without delay forward the report of the investigation of IO, who shall forward it to the magistrate. In terms of a female, there is a kit which is used for test. This is how the kit looks. This is a sexual assault evidence collection kit. It has got various things inside it, this kit, and this kit is used for doing examination of all the female victims of rape. So this is the sexual assault evidence collection kit. So this kit is called in short as a rape kit. So this kit has multiple dimensions, which has got documentations. So there are multiple documents inside this box, which is a victim consent form, where the victim explicit consent for the examination provides that. History form, which talks about the any medical history of the victim. Then there are evidence collection containers like swabs, sterile cotton swab sticks, small boxes to collect box liquids and saliva and other biological liquids. Specimen collecting bags are also there to bring in various clothes and other items to be put into that. Sample collection is for blood sample collection, hair collection, sample collection, urine sample container. Physical evidence collection, fingernail clipping, hair collection. Surgical gloves are also there in this box, like disposable gloves. Sheets or specialized examination clothes are also there, which is folded and kept in this box. This box has that cloth which she can wear at that time of examination so that the maintain the dignity of the victim's privacy. There are forensic tools also in this box called wooden or plastic spatulas. Scissors are also there to be used specially for this so that it does not contaminate using any other scissor, which is used at some other place. Then a small one-time click camera is also used, and markers and labels, stickers are also there inside this. Apart from that, there is a contraceptive medicines and some infection medicines so that the victim is not infected by some sexually transmitted disease. So those medicines are also available in this box. So this is used for evidence collection, victim care also, and to make it standard. Coming to section 54. So examination of arrested person by medical officer. We are going little beyond time, but it's only 6 more sections are there. We can continue. So examination of arrested person by medical officer. Now, the person has been brought to for medical examination, the arrested person. So when the person is arrested, he shall be examined by a medical officer in the service of central or state government. This is prescribed. The word prescribed means he is so and so working in so and so cadre of service. And in case of medical officer is not available by a registered medical practitioner soon after the arrest is made. If required, that can also be done. Provided that where the arrested person is a female, the examination of body shall be made only by or under the supervision of a female medical officer. Clause 2 says the medical officer or registered medical practitioner, so examining the arrested person, shall prepare the record of such examination, mentioning therein any injuries of or mark of violence upon the person. And where an examination is made under subsection 1, a copy of the such examination shall be furnished by the medical officer or registered medical practitioner to the arrested person or the person nominated by such arrested person. So whatever is discovered on that person medically has to be shared by to him, her, or to the person indicated by that arrested person. So mandatory examination is there. Alternative examination is also provided in section 54. Special provisions are also there if the person is female. There is a record documentation has to be created. A copy of the report has to be handed over for fairness so that tomorrow there is not a second report presented in the court which was not actually handed over to the accused. And objective is to protection of rights, documentation of legal processes, and control established in terms of gender sensitivity. Section 54A was added, which was a very, very important clause, where is identification of person arrested. So there was a problem which was seen in a lot of times in the courts where it was not really ascertained by the police that in any document providing indicating that actually the person is arrested is the person who was supposed to be arrested. So where a person is arrested on charge of committing an offense and his identification by any other person or person is considered necessary for the purpose of investigation of such offense, the court having jurisdiction may, on request of the officer in charge of the police station, direct the person so arrested to subject himself to identification by any person or persons in such a manner as the court may deem fit, provided that if the person identifying the person arrested is mentally or physically disabled, such process of identification shall take place under the supervision of a judicial magistrate who shall take appropriate steps to ensure that such person identifies the person arrested using methods that person is comfortable with, and provided further that if the person identifying the person arrested is mentally or physically disabled, the identification process shall be video photographed. So this is about the identification parade, which can happen for the person who has really committed the crime by the victim. In case of the victim is not is somebody who is mentally or physically disabled as per the definitions of the law, or the person is mentally or physically uh, disabled, and in that case, judicial magistrate has to be there. Proper psychiatrist has to be there, because judicial magistrate will call for a psychiatrist. They will call for a relative to understand the particular person. Then this whole incident has to be recorded. So it is pointing towards an identification, towards an accurate identification. Mistaken identity cases could be minimized with this. Facilitation of the legal process against the right accused happens. Enhances the investigating process. With confidence, the courts can move on that this is person who is supposed to be accused. The standard practices are there to be applied everywhere, and safeguarding individual right with facilitating the victim identification even for a mentally or physically disabled person. Where assistance is required, it can be required, but it has to always be with a court's authority or request from police. For investigation purpose, police might request, um, and then it can be done, or if the court believes it has to be done. The condition for identification has to be a judicial oversight, because it cannot be just for fun. It has to be for a reason that it has to happen, judicial reason. Vulnerable person who has to identify the accused is mentally or physically disabled, then supervision is there, comfortable method is there, where the person, the way he or she is, you know, comfortable, they can do it. And video recordings are also to be done, and documentation has to be done. So objective is facilitating the investigation, ensuring the fairness, and protecting vulnerable person by standardization of the procedure as well. So this is what an additional step which was added via section 54A, and then further it was enhanced with the last two provided you see on the screen, last two clauses by Criminal Law Amendment Act of 2013. Section 55 talks about procedure when police officer deputes subordinates to arrest without warrant. Now, a police officer for some reason might need his junior officer to go and during an investigation, like to arrest. For when an officer in charge of police station or any police officer making an investigation under Chapter 12. Chapter 12 is what? Information to the police and their powers to investigate. So this is related during investigation, requires an officer subordinate to him to arrest without a warrant. Otherwise than in his presence, any person who may lawfully be arrested without a warrant, all the previous clauses we have seen, he shall deliver to the officer required to make the arrest an order in writing. He has to give an order in writing, specifying the person to be arrested and the offences or the other cause for which the arrest has to be made. And the officer so required shall therefore, making the arrest, notify to the person to be arrested. He will serve a notice and the substance of the order, and if so required by person shall show him the order. And nothing under this stops the police to arrest somebody under section 41. So if 41 is applicable, the person anyways will be arrested. Otherwise, during investigation under chapter 12 given procedures, police can ask his subordinate then why this person has to be produced, and the subordinate has to go back and whisper the same in the ears of the accused. And the accused, in case of is not satisfied, want to see the order, has to show the order, and then the person has to cooperate. If the person is not cooperating, then an arrest is definitely possible, and required restraint can also be applied. So delegation of authority is something which is discussed in this one. A written order is mandated as one of the ingredient. Identify the person and the offenses in the writing is one of the ingredient. Notification to the arrested person has to be given in advance, and it is not overriding effect on section 41. 41 is individually applicable in case it is required. So it brings in the accountability in the arrest, transparency, and the necessary of the legal compliances which is required is part of this. Now, 55A was added. Now, health and safety of arrested person. It shall be the duty of the person having the custody of the accused, of an accused, to take reasonable care of the health and safety of the accused. Means any accused which is kept in a police station or a judicial custody in a particular jail, the jailer of that jail or the in charge of the police station is a responsible person to ensure the health of the custody. So health and safety obligation is added via 55A. And in the protection of human right, preventing mistreatment, accountability, legal compliances, and ethical standards are followed, and implementation of a custody setting, custody safety is done using 55A. So if you are responsible of a person's sound mind and health, you will put all the required necessary efforts around that, and to enable that and to to let that happen, this 55A was added a clause. And plus, there might be a health need of the person as well. Some pre-existing elements might be there. Section 56 talks about person arrested to be taken before magistrate or officer charge of police station. A police officer making an arrest without warrant shall, without unnecessary delay and subject to a provision herein contained as to bail, lay, take or send the person arrested before a magistrate having jurisdiction in the case, or before the officer in charge of police station. So the very important ingredient, crisp, which coming out from section 56 is it has to be timely action. It cannot be a delayed. So cannot be unnecessary delay. So necessary, unnecessary, reasonable, these are very important keywords. And it cannot be an unnecessary delay. If there is a delay, it has to be proved why the delay was there. It has to be subject to bail provision. So the section acknowledges that the action of taking the arrested person before a magistrate or a police station officer is subjected to provision related to bail. This means if the arrested person is entitled to bail, he can be addressed during this process, allowing for their release if applicable. So previous section, we talked about giving him opportunity to have bail, inform him about that. That is included in section 56 also. And so this is a judicial oversight to ensure preventing arbitrary detention, protection of rights of person again, and transparency in arrest. Section 57 talks about person arrested not to be detained more than 24 hours. So no police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not in absence of a special order of magistrate under section 167. So why magistrate order? Because a magistrate order is obtained with certain reason, and the magistrate must have given a timeline under which the person, for that timeline, the person can be detained 2 days, 3 days, 72 hours, 15 days, a month, whatever was mentioned in the order by the magistrate, or in such case it is not there, not more than 24 hours, the person has to be detained not more than that. The person has to be produced. That is the law. So maximum detention period is 24 hours. It's only in the Bollywood. You arrest on a Friday and the person can be seen only on Sunday. Courts are open every day. Exclusion of travel time. So when we say reasonable time, the time is excluded by any reasonable time used for travel. Need for magistrate order required for more than 24 hours in any cost. So it helps in putting the protection of personal liberty, preventing any abuse of power, and it has a judicial oversight. That requirement for a magistrate's order is something which is helping putting a judicial oversight that how much duration that person should be in detention, and this is a post-arrest procedure, and this has a legal compliance attached to it. Section 58 talks about police to report apprehensions. So officers in charge of police station shall report to the district magistrate, or if he so directs, to the sub SDM, the case of all persons arrested without warrant within the limits of their respective stations, whether such persons have been admitted to bail or otherwise. So this is again an obligation, because all criminal jurisdictions are is also responsibility of the district magistrate. So all the well-being of the person in that district is the responsibility of the district magistrate as well, and it is an obligation of the report of the police to ensure they are reporting it. And alternative reporting is also given in case of it needs attention from an SDM. Normally it is done to SDM only, different division wise. So it it creates an accountability. It creates a tracking report. It creates a judicial supervision. and it gives a statistical and administrative report also. Coming to section 59, discharge of person apprehended. No person who has been arrested by police officer shall be discharged except on his own bond or on bail or under the special order of magistrate. So, for non-cognizable offences or some small cognizable offences also, the very first opportunity given by CRPC will see further is at the police station, where the police station in charge can allow the person by evaluating on his own risk a discharge that he will cooperate and let him go by a furnishing of on a personal own bond, surety, or whatever it is. Then, otherwise, via magistrate in the court. Otherwise, there is no other third option. So, once you are arrested, only there are two means of exit out of which is section 59. So, this is modes of discharge which is given here, like own bond, bail, special of order of a magistrate. And what objective is achieved by section 59 is prevention of arbitrary release. If police can arrest arbitrarily or any law enforcement can arrest arbitrarily, it is very well understood they can release arbitrarily also in under for some favor. So this is prevented. Ensuring compliance. So it has to go through certain procedures to ensure the judiciary is looking into the compliance, and that's how the judicial oversight also happens. And there is a clarity in the legal process so that every matter is uniformly handled by the police as per the law. So it implements a arrest scenario up to the release. Section 60 talks about powers on escape to pursue and retake. So, but naturally, if a person in lawful custody escapes or is rescued, means his people come and take him away, the person from whose custody escaped or was rescued may immediately pursue and arrest him in any place in India. This cannot be a private person. So you have arrested somebody and you are going to hand him over to the police station or a police officer and he escapes. You try to catch him again, fine. Otherwise, you cannot go across the India to find him. You have to report to the police station. And the provisions of section 47 shall apply to arrest under subsection 1. I said you have to remember section 47. So this is where you can open doors or windows or you can take help of the owner of the building, the police officer, and they can make an arrest. So they can go across India as have an authority to pursue that person. And application of section 47 is also applicable in due course if it is required to search and fetch that person from some premises. And the objective is to maintain a custodial integrity. It has to have a custodial integrity that the person who is in custody should be in custody until he is not discharged as per section 59, and an immediate action has to be done. We cannot wait for that. It might be harmful for the delivery of the justice. Empowerment of custodians is very, very important. And this is what is covered in section 60. And the last section for today's arrest to be made strictly according to the code. No arrest shall be made except in accordance with the provisions of this code or any other law for the time being in force providing for arrest. So strict adherence for every aspect of the procedure of the arrest, upholding the legal integrity, preventing the arbitrary detention, promoting the accountability, and applying the various aspects of the law for human rights and the guidance of law enforcement and judicial review. So that's all for the lecture today. I will switch off the recording now and we can have a question answer session. And I don't know where to find the recording. Just bear with me for a minute. I'm stopping the recording.